Hello, I'm John Bursch, Vice President of Appellate Advocacy with Alliance Defending Freedom. I appreciate you joining me for my session, looking back, looking forward, and finding hope at the U.S. Supreme Court. Well, it was certainly a turbulent and interesting year at the U.S. Supreme Court, and this coming fall promises to be another one. There were good decisions, there were not so good decisions, but plenty of reasons for us to find hope and to care about the Supreme Court going forward. So I'm going to give a 10,000-foot overview of some of the most important cases from the past term as they pertain to religious liberty, and also give you a preview of the cases that are to come. I'll start with one of the most widely publicized cases of the previous term, Bostock, which of course involved Title VII, the federal employment law that prohibits discrimination because of sex in employment. Bostock was actually three decisions. I argued one. The first two decisions both asked whether that Title VII provision includes discrimination or differential treatment based on sexual orientation. One involved a skydiver, the other involved a county employee. They both alleged, although their employers denied, that they were fired solely because of their sexual orientation. My case was on behalf of Harris Funeral Homes. It's a Detroit-based family business that has been serving grieving family members for more than 100 years. Like every funeral home, they had professional codes of conduct as well as dress, including a sex-specific dress code to ensure that their clients could focus on processing their grief and not on the funeral home or its employees. Well, they had a funeral director, kind of the face of the funeral home, a male who had been in that position for nearly 6 years. And then that employee announced to the owner, Tom Rost, that he would be gone for a period of about 2 weeks, and then upon returning would be dressing and presenting as a woman. Tom thought about this and considered not only the employee who was obviously suffering in distress, but also thought about the employee's wife, thought about the company's employees, and thought about the grieving clients that the funeral home serves, and ultimately decided that he could not go along with that plan. As a result, the EEOC brought a lawsuit and claimed that the company had engaged in sex discrimination. And so that's how this trio of cases got to the U.S. Supreme Court. Now, start with the good news in the decision. In a 6-3 opinion written by Justice Gorsuch and joined by Chief Justice Roberts and the court's 4 liberals, the court affirmed that sex in federal law means what we all expect it to mean: biological sex, something that can be determined based on reproductive biology. It's objective and cannot be changed. Nonetheless, the court said that it did violate Title VII to terminate someone because of their sexual orientation or their transgender status. Now, this was a surprise to many. After all, the courts, including the U.S. Supreme Court and the EEOC, had consistently interpreted the statute for nearly half a century as applying to the situation where women were treated worse than men because they are women, or vice versa. No one had, until very recently, ever contemplated that the statute had any application based on sexual orientation or transgender status. And yet that is what the court held. It was a particularly curious decision because in interpreting statutes, the court looks at their general public meaning, the way an ordinary American with a reasonable command of English would have understood the language at the time of its enactment, in this case 1964. And no one in 1964 would have anticipated that Title VII covered sexual orientation and transgender status. In fact, the whole notion of transgender status was only a nascent concept at that point, having been introduced at a European conference only a short time before. What's more, many states had enacted policies, as well as local governments, that added sexual orientation and gender identity to civil rights ordinances and statutes, all believing that they had actually accomplished something. Little did they know that buried in this 1964 statute, those protections had been buried there the whole time. It wasn't very much of a textualist decision. In fact, even though Justice Gorsuch is a textualist, the best criticisms of the decision are on textualist grounds, although we don't have time to get into those today. But there is some hope on the back end of the case, too. You see, the majority opinion reserves many of the most important questions in the case. First of all, the opinion reserves the question of sex-specific policies as they are applied based on biological sex. So for all the employers out there, what that means is the court has not yet decided whether you can apply a sex-specific policy based on biological sex to things like showers, restrooms, locker rooms, overnight accommodations, or even dress codes, which was supposed to be the issue in the Harris Funeral Homes case. That issue will have to be litigated further in the lower courts. The court's opinion also did not purport to address the sticky issue of athletics. and whether their interpretation of Title VII would apply to allow a male who identifies as female to participate in female athletic competitions. Finally, the Supreme Court majority opinion specifically reserved the question of religious liberty. The court mentioned the Religious Freedom Restoration Act, which is the federal act that guarantees religious liberty from being violated by other federal laws. It described that as a super statute, one that supersedes other statutes that could be very promising in future cases, but also withheld judgment with respect to other religious liberties, including the Free Exercise Clause. So while in the short term, this was a setback for those who hold Catholic views on marriage and human sexuality, to be sure, there is much more to be litigated and certainly lots of hope. As we'll be discussing, the Supreme Court in other cases continued to keep the door open for religious liberty in a wide variety of ways, making all of us believe that the Supreme Court will find a healthy balance between these two things, Title VII and religious liberty, as cases go forward. The next significant opinion that was of wide public interest was June Medical Services. And this involved a Louisiana law which required hospital admitting privileges for doctors who were performing abortions within the state of Louisiana. It's a requirement that Louisiana already had for doctors at ambulatory surgical centers in all parts of the state. So it was just bringing abortion doctors into compliance. And it really served two purposes that were intended to protect women. Number one, if you are credentialed with admitting privileges at a hospital, it's ensuring that you're a good doctor, because after all, a hospital would not give admitting privileges to someone that it thought was negligent or incompetent. And that was a huge problem in Louisiana because the legislature had before it, as it considered the legislation, substantial testimony and documents showing that abortion practice in Louisiana was absolutely horrible, with examples that ran the gamut, sometimes looking like the Gosnell case up in Pennsylvania. The other thing that admitting privileges do is they ensure continuity of care when there are complications that arise during an abortion procedure. For example, in Louisiana, they had testimony about a woman who was on the operating table and started to bleed excessively because the doctor did not have admitting privileges. He simply left her there on the table for several hours and then had an assistant drop her off at the hospital emergency room without communicating with the doctors at all about what was going on. It took the doctors at the hospital quite some time to figure out that these complications even arose from an abortion procedure. And as a result, although they were able to save the woman's life, she was permanently sterile after that. Well, in spite of these things, the case came to the Supreme Court in a difficult position because only a few years ago, in Whole Women's Health versus Hellerstadt, the Supreme Court had struck down essentially an identical hospital admitting privileges requirement in the state of Texas. And although Louisiana claimed that it had much better evidence than Texas did of how this was going to help women, and that its practical effects did not impede abortion nearly to the extent that the Texas statute was alleged to have done, Chief Justice Roberts filed a concurring opinion that concurred in the result of an opinion written by 4 justices to strike down the law based on that Texas precedent. So again, up front, this is terrible news and a setback for sure for the pro-life movement. But even there is substantial hope because Chief Justice Roberts did not join the majority opinion, but wrote separately. He was able to articulate the reasons why he reached the result that he did. And it was simply because he felt compelled by the court's precedent issued only a couple of years before in the Texas case. But he did a number of other things in connection with the 4 dissenting justices that should give us a lot of hope about challenging pro-life or defending pro-life legislation in the future. Prior to Whole Women's Health, the Supreme Court had applied an undue burden standard in pro-life cases. Under that standard, so long as a law had a rational basis that the legislature could articulate, and it didn't impose an undue burden on a woman's right to an abortion, it was valid. Whole Women's Health, in contrast, suggested that the interests of the legislature in enacting the law and the burden on a woman should be balanced against each other, which gave judges substantial more discretion to decide for themselves when abortion restrictions should rise or fall. Well, Chief Justice Roberts disavowed that, and as one of the dissenting justices noted, there were 5 votes to disavow that reasoning in Whole Women's Health. So what that does is it rolls back that balancing reasoning and reestablishes the undue burden standard. And based on that, the court remanded several other abortion cases involving ultrasounds and other things, which we should have great reason to hope will be upheld given that standard. In fact, an 8th Circuit court just only a few days ago, upheld new restrictions on abortion in the state of Arkansas and cited the Chief Justice's concurrence in its reasoning. So even though the result in June Medical Services was not what we would have hoped for, over the long term, this could significantly help us in advancing pro-life legislation and then defending it in the courts. Another reason for good news is the court's decision in Espinoza, which essentially invalidated Montana's Blaine Amendment. For those of you who aren't familiar with Blaine Amendments, they were the invention of a U.S. Senator Blaine in the late 1800s. He came up with the idea of trying to ensure that no federal funds would ever be given to sectarian or religious schools. At the time, sectarian was code for Catholic, because he wanted to ensure that no Catholic schools ever got the benefit of any government funding whatsoever. While U.S. Senator Blaine was unsuccessful in amending the U.S. Constitution, his effort did bear fruit at the state level, and I'm sad to report that some 38 states now have their own versions of Blaine amendments that prohibit the use of public monies for sectarian or religious schools. Well, one of those was in the Montana Constitution. In fact, it was required to be included in Montana's Constitution as a condition of Montana being entered into the Union as a state. And that amendment came into play when the legislature passed a new program which created a scholarship fund that anyone could donate to and receive a tax credit. And those scholarship monies could then be used by students to attend the private school of their choice. Well, as soon as that law went into effect, the Montana Department of Revenue held up its hand and said, hold on a minute, we have a Blaine Amendment, and that means those monies cannot flow towards private religious schools, only private secular schools, and it issued a revenue ruling on that basis. The Montana Supreme Court affirmed and threw out the entire program, and it went up to the Supreme Court on that basis. Now, a few years ago, Alliance Defending Freedom obtained a big win in the Blaine Amendment context in Trinity Lutheran. You might recall that was the case involving playground resurfacing grants in the state of Missouri, and the Supreme Court said that in that context, the state could not discriminate against a religious school, but had to treat it on the same basis as public schools or private secular schools. The Supreme Court expanded that ruling in the Espinoza case and built on its foundation by holding that whenever the government chooses to provide assistance to private schools, it cannot discriminate on the basis of religious status. That means categorically religious schools, religious students families cannot be excluded by a Blaine Amendment from participating in a school choice program, whether that be scholarships as in Montana, or vouchers, or tax credits, or educational savings accounts, or anything else whatsoever. You can immediately appreciate how this is a broad win for religious liberty that will be used in many, many cases as we go forward. The final case on the court's last term addressing religious liberty is Our Lady of Guadalupe. This was a case involving the so-called Ministerial Exception, which is an exception to Title VII, the statute we were just talking about in Bostock, that says that when you've got a minister, someone who is trained and charged with propagating the faith for a religious organization or a church, then the federal government and the courts have no say in who they pick for those ministers, notwithstanding federal employment laws to the contrary. You can immediately appreciate how this works in the context of our Catholic faith. It's what prohibits women from suing Catholic churches because they're not being hired as Catholic priests. Those ministers are allowed under this ministerial doctrine to be selected solely by the Catholic Church without government involvement. Well, in a case called Hosanna Tabor a few years ago, the U.S. Supreme Court in a 9-0 decision had affirmed this ministerial exception, which had existed in the lower courts for many years. But in that case, it involved a religious teacher who had the title of minister and had a theological background. She had been trained specifically in theology. Our Lady of Guadalupe, in its companion case, St. James School, were both Catholic schools where the teachers did not have the title of minister and did not have theological training, and yet obviously were being put in a position to propagate the Catholic faith. They were taking the kids to Mass, leading them in prayers during their classrooms, and teaching secular subjects in accordance with the Catholic Church's teachings. Well, the U.S. Supreme Court, in a huge win for religious liberty, held that they too could be considered ministers, even though they lack the title, even though they lack the theological training. This opens the door for Catholic churches and other churches and religious organizations to basically decide who their ministers are, if in good faith they are being used to teach the faith to others, whether that's through evangelization or in a classroom setting. And so, immediately this has the impact of softening the ruling in Bostock. Now, before we go on to the new term, I'll note that a number of the questions that the court did not answer in Bostock are going to be litigated and likely decided in the U.S. Supreme Court within the next couple of years. When it comes to athletics, those cases are already filed and pending. Alliance Defending Freedom has several of them, both in Connecticut and Idaho. Also questions involving the use of pronouns when it comes to those who claim a transgender status. We're litigating one of those cases in the Sixth Circuit right now and another in a federal district court. And in just about every other context that you can imagine, we'll see these cases. Many of them will be impacted by the next case that I'm going to be discussing, which will be on the court's docket this fall, one of the first that it'll be hearing. You may have heard of this one already because of its infamy. It's Fulton versus the city of Philadelphia. And this involves Catholic social services in the city of Philadelphia, which was prohibited from doing any more adoptions or foster care work in the city because of the Catholic Church's teachings on marriage being between exclusively one man and one woman. There were no complaints that had been filed against Catholic social services. In fact, to our knowledge, no same-sex couple had ever even applied for an adoption license through Catholic social services. Nonetheless, the city, for political reasons, decided that any adoption agency that would not place children with same-sex couples had to be excluded from the program, no exceptions. Everything was over. A federal court of appeals upheld a district court which denied any relief to Catholic social services, and that case is now at the U.S. Supreme Court. It's significant because it will not only decide the question of Catholic social services' right to religious liberty in the adoption context, but it'll likely decide the broader question of whether Employment Division versus Smith stands. This is a Supreme Court precedent which had the effect of severely restricting the free exercise clause. It said several decades ago that if you have a government law which is neutral on its face and generally applicable, then it will not be held to violate religious liberty rights unless one of a few exceptions are met, including evidence of religious animus. Well, that provides a problem in a context like the city of Philadelphia, or when you have creative professionals who are confronted with a public access ordinance, one that prohibits discrimination based on sexual orientation or gender identity. If the Supreme Court reverses Employment Division versus Smith, that opens up a whole panoply of free exercise defenses for Catholic adoption agencies, for churches, for creative professionals, and others who want to not only believe their faith, but to actually practice it, to exercise it in the public square. Another case that the court will be hearing, that one of my colleagues at Alliance Defending Freedom will be arguing likely in December, is Uzwe Bunam. This is a case involving free speech on a college campus, and whether after the college officials change their policy, you can still go forward and get a ruling for nominal damages based on the constitutional violation that took place. We have great hope that this will open the door for other rulings in cases where government officials lead folks along for many years and then all of a sudden change their policy at the last minute to try to ensure that there is no court ruling to say that their constitutional rights had been violated. Other cases that could be on the court's docket include a couple of cert petitions that we filed at Alliance Defending recently, including the Bruni versus City of Pittsburgh case involving the free speech in abortion buffer zones outside abortion clinics in the city of Pittsburgh, and Thomas More Law Center, which is the Religious Liberty and Pro-Life Advocacy Center located in Ann Arbor. The state of California has a policy of requiring nonprofit groups to disclose their donors to the state attorney general's office when you solicit funds in California. And frequently in the past, that information has been leaked like a sieve by the state officials who hold that information. For a group like Thomas More Law Center, which holds Catholic positions with respect to marriage and human sexuality, that can result in all kinds of trouble because members of their staff and their clients have been harassed and protested and abused by others when they found out about those positions, and they don't want their donors to be harassed or even to have the threat of harassment out there. And that's a case we're hoping will be heard this term as well. So as you can see, even though there were a few bumps in the road this past term, there are great reasons for hope. We certainly have hope at Alliance Defending Freedom, and I know our friends at the Becket Fund for Religious Liberty, which will be handling the Fulton case, and many of our other allies also have hope that we can continue to keep the religious liberty barricade strong and in place in the U.S. Supreme Court and in the lower courts in the United States. It also shows to everyone how important elections are. We always say elections have consequences, but nowhere is that more true than at the U.S. Supreme Court, whose decisions often will bind the entire country for many, many years into the future. Our U.S. Supreme Court is not perfect. Obviously, there are cases that they issue that we wish would go another way, Jew Medical Services and Bostock being primary examples of that. But there is much to like about the justices on the Supreme Court, and given the age of some of the other justices on the court, it's entirely likely that the next president of the United States will be picking their replacements. And so that just goes to show that we need to be engaged in this fall's election and to ensure that we have a president and a Senate who will nominate and confirm justices who will continue to respect and defend religious liberty at every opportunity. So with that, my time has concluded, but I appreciate you for tuning in. If you have additional questions, feel free to reach out to me. You can get a hold of me at jbursch, B-U-R-S-C-H, at adflegal.org, or access more information about the many religious liberty cases, the free speech cases, the pro-life cases that we are litigating on our website, adflegal.org. Thank you, and have a blessed day.